Well, it's Thursday, the 3rd of October in the year 2024. Thank you so much for joining us for this week's edition of This Day. I'm your host. My name is Andrew Mwansa. Now, last week, former President Edgar Lungu applied for the recusal of the 3 of the 7 judges presiding over his eligibility petition, accusing them of bias in a case that could reshape Zambia's political landscape. The news is that the 3 Constitutional Court judges have refused to recuse themselves. I sat down earlier on with prominent historian Dr. Sishuwa Sishuwa. I asked him what he thinks about this particular case, owing to the fact that he was one of the petitioners that petitioned the eligibility of President Edgar Lungu to contest the 2021 general elections. Dr. Sishuwa Sishuwa, thank you so much for accepting to speak to us on this day tonight.
Thank you so much for having me.
A lot is happening back here in the country. Obviously, the eligibility of President Lungu to contest the 2026 elections is back. His eligibility to contest the 2021 election is also a part of the court's process now. Interestingly so, because you are one of the people that petitioned his eligibility to contest the elections of 2021. Let's begin off from there, Dr. Sishuwa Sishuwa. What is your take on this case that has resurfaced?
Well, there are many elements of the matter that we could discuss, but it's correct that I petitioned the eligibility of Edgar Lungu in 2021. You see that there are two ways of dealing with election-related at the presidential level, and 2 clauses that the Constitution gives us or empowers us as citizens to deal with any election-related disputes. The first happens before the election itself, and that one is under Article 52, which allows a person to challenge the nomination of a candidate within 7 days following the declaration of final nominations. Now, if you are aggrieved, for example, and say, look, I believe this person is not qualified to stand for this particular office, say the office of the president, you can take a matter to court and ask the court to determine that. That opportunities are available only after the filing of nominations and within 7 days after that. And then the court will have about 21 days to determine that matter within a period of at least 30 days before the election. If you don't go to court before the expiry, if you go to court after the expiry of that 7 days, the matter cannot be entertained because you would have gone beyond the time that is stipulated in the Constitution. And also, if you go to court and say, I want Costa Mwansa or Andrew to be disqualified, it will be premature because Andrew has not told you that he wishes to stand for election to that specific office. So what we did in 2021 was to wait until Edgar Lungu had filed his nomination papers, and then we approached the Constitutional Court because we said Lungu is not eligible. We believe that he's not eligible. Lungu and his supporters said, no, we are eligible to stand for another term of office. And because of that disagreement in opinions, we approached the competent authority to determine that disagreement. At the end of the process, the court said Lungu was eligible to stand for the 2021 election. After that judgment was passed, it didn't matter what I thought about Lungu in terms of my opinions. My opinion becomes secondary. What the court decided became what was, the lawful position. And even if I disagreed with that judgment, I respected it. It is that judgment that gave Edgar Lungu the accrued right to stand in another election, because there is no limit to how many times a person can stand for president if they keep on losing, for example. Hichilema, who is now president, stood many times. He lost many times. Nobody said, hey, you have lost enough, can you park? So that's one way of dealing with elections. grievances where you petition the nomination of a candidate. That process happens before the election date, but after the nomination and within a specific time frame. The second opportunity happens after the election. If, for example, you feel that the person who has won the election has done so in a fraudulent manner, you can go to the Constitutional Court within 7 days following the declaration of the results to petition the results. You could also do so by saying a particular provision of the Constitution was not complied with or was violated. Again, that opportunity is only available within 7 days following the declaration of the results, and the court has 14 days to hear and determine the matter. If you forfeit that, if you don't go to court within that time frame provided by law, you forfeit the right to petition the outcome of that election. Now, the problem with this case, for example, that has been brought forward now is at two levels. The first is that you see there has to be finality to these things. You can't keep beating the system until you get the results that you want. By virtue of the 2021 ruling of the Constitutional Court, Edgar Lungu is eligible to stand in another election. As Sishuwa, if Lungu stood today, I will not vote for him because I know what he's capable of, because I've seen his capacity in terms of leadership. I criticized Lungu when he was in power, and I've not forgotten what he is capable of, and I don't think he has demonstrated that he has changed in a way to actually end my vote. Even though I'm opposed to Lungu, however, I would defend his right to participate in the political affairs of his country, including his right to stand in the next election based on that judgment that was passed by the Constitutional Court. You have to remember that it wasn't the first time that the court was making that judgment. It was the third time, because there have been two other cases before. But the key point is that the latest case, for example, I don't know if you look at the two provisions of the Constitution I've highlighted, the nomination one, it doesn't apply there because you can't bring it beyond 7 days after the nominations. It also doesn't apply to the Article 101 of the Constitution, where somebody can bring a case within 7 days after the declaration of the results. I don't know what authority the Constitutional Court, which itself is the creation of the court, would use to hear the matter to say, well, you have found this matter is competent before us because there is this provision, that provision allows you to bring it here. You will have to wait and see the judgment that the Constitutional Court will make in the case at the end of this process, because they have accepted it.
Do you find this petition irregular? Like you rightly mentioned, Dr. Sishuwa, that when a matter goes to court and the Constitutional Court determines that matter, it becomes law, and this law becomes binding on all of us, whether we like it or not. But there are citizens that feel that the Constitutional Court perhaps might have erred in the process of making that particular decision. Does it make it wrong for any citizen who feels the Constitutional Court erred to go back for the Concourt to relook at their decision?
You see, the Constitutional Court cannot make a right or wrong decision, for example, because it's right according to whose perspective, or wrong according to whose perspective. The Constitutional Court has the obligation to interpret the Constitution. We can go to the court and ask them to determine a matter, and they determine. Once they have determined, we have to respect that. We may disagree with their judgment, but we respect that. The challenge here is that this is the fourth time this matter is being taken back to court. The first time, I think it was Danipule and his friends. In my view, that case by Danipule was quite irregular, in the sense that you can't again, predict that somebody will be interested in standing if they have not filed their nomination. You have to wait for the formality, for the formal process of nomination to take place before you can actually sue. They jumped the gun and they went to court. The court made its determination, even at that early age, at that early stage, that Lungu was eligible to stand. And then there was, I think, Bampi Kapalasa, and he went to court also. The court ruled in the same manner. So by the time we were coming up in 2021, it was the third time, and they maintained the same ruling. Now, nothing has changed between 2021 and now in terms of the law on which the court based this decision. Nothing has changed in terms of the material facts of the case, to say, from what they have ruled in the past to say, because of this fundamental change in the law, for example, or material facts, we are going to review this matter. Citizens can go to court, but the Constitutional Court is a court of first and final, authority. They determine a matter. There's no direct appeal, the way, for example, you can go and appeal at the High Court or Supreme Court if you are unhappy with the decision of the Magistrates Court of the High Court itself, and the Court of Appeal in the process, in between. Now, you have to decide at some point to say, at what point do we accept that there's finality to this thing? Because if you are going to take the case of this UPND activist, for example, who has sued Edgar, they go and decide and say Edgar is not eligible, for example. What stops somebody else tomorrow from going back to the same court to say, can you revisit this same ruling? And for how long does that continue? At what point do you say this is enough? We have to stop here because we have litigated enough over this matter. Please take into account that we are dealing with courts here, not individuals in this court, but court as an institution. You have, for example, the Attorney General's office. In 2021, the Attorney General's office said Lungu is eligible. They're part of that team that was opposed to what I was saying. Now you have the Attorney General's office, the same office saying the opposite. The same office. We shouldn't personalize these things to a point where we are looking at it at the individual. We have to deal with it in relation to institutions. There's no way the same court can rule 3 times that this person is eligible and turn around after a change of leadership, in 2021, to say, in fact, all are wrong, we're wrong, this man is actually eligible. It damages the credibility of that particular institution, because you can't have a scenario where judges shift their position based on who is at the helm of the executive. But also in the event that you have these new judges who have been appointed there by President Edgar, deciding that matter in a manner that, say, is disadvantageous to Lungu, there will be a perception by many people out there who think that these judges are there to serve the interest of the appointing authority. Because how is it possible that all of them, the new ones, have a verdict that is different from the ones who were there before? If the ones who were there before will be perceived as people who were serving the interest of the president at the time, the new ones will be seen as people who are serving the interest of the person who appointed them, that's President Edgar. So there are these ramifications in terms of the credibility of the court itself. You see, it will be severely undermined by a decision that throws away everything that has been decided in the past. Of course, we'll have to wait and see the reasoning behind the decision that will be made, or however way it goes, and then on that basis make our own commentaries.
We get into the details of what the implication, if the Concourt rules that indeed Edgar Lungu was ineligible for the 2021 elections. We'll look at the possible implications. But this eligibility of President Edgar Lungu comes just at the backdrop of President Hakainde Hichilema, having to suspend 3 of the Concourt judges. These include Justice Anne Sitali, Justice Mungeni Mulenga, and Justice Palan Mulonda. Do you see this as a coincidence or a well-calculated move to try and knock out President Edgar Lungu from the race?
The timing of which is problematic. You see, it's very difficult to make a very definitive analysis of this matter because of the secretive manner in which the Judicial Complex Commission that generates this kind of outcomes operates. We don't know. They say they submitted the report to the president that recommended to the president the suspension of those 3 judges. Nobody knows the particularities of that report because it is confidential. It is secretive. But based on what, to the best of my knowledge, the complaint on which those 3 judges have been suspended is based on the outcome of the 2016 election petition. you have to remember that after that election, the current president at the time in opposition petitioned the outcome of that election as provided for by law. The Constitutional Court at first instance, all 5 judges at the time decided that this matter will continue, say on Monday, I think it was a Friday, and it was a unanimous decision, 5 of them. Then come Monday, there was a strange circumstances where somebody else, the judge, 3 of those judges said, rather the court decided that we should abandon this thing because of that lapse of time. Those 3 judges who have been suspended are the ones who said that the petition must be terminated at that stage because they had run out of time. The other 2 judges, Justice Margaret Mnarula and Hilda Chibomba, who has since retired, disagreed with that position, saying, no, once the matter has been filed, it should be properly be finished. You have to understand that at the time when that petition was being decided, I think it was only about 8 months after the enactment of the amended constitution. So it was early days, so to say. It was, I think, the first time actually that we're dealing with an election petition within a time-bound context. We are dealing with human beings here. These are people who are not saints. They could have made their mistakes, for example. It was the first time they were deciding this matter. But that was what happened. Now, Hichilema at the time was very unhappy with the decision taken by the 3 majority. He accused them of being under he accused them of corruption and being under the control of then President Edgar Lungu. As a result of that matter, a number of people went to the Judicial Conference Commission to ask the JCC to remove these judges for gross misconduct or incompetence. The first one was Peter Sinkamba, who did so in 2016. I think the matter was concluded in 2017 under Christopher Mushabatu, who was the JCC chairperson at the time. Over time, we had 7 other people who returned to the JCC with the same complaint, seeking the removal of these 3 judges. Okay, Sinkamba had actually asked for the removal of all of them. What was striking about this subsequent complaints was that they were limited largely to those 3 judges. And secondly, they were mostly led by UPND supporters. The JCC decided for 8 times that this matter was closed, was decided, and there was no need to reopen it. Things changed in June this year when 2 of the JCC officials, you have to remember that the JCC leadership changes after 2021. Vincent Malambo is appointed as the chairperson, and you have 4 other people appointed by President Hichilema. The Malambo-led JCC is part of the body that is making the decision to say we can't hear this matter because it has been decided already. Then in June, after 2 commissioners' terms of office came to an end, you had 2 new commissioners who were appointed by President Hichilema. I think they were sworn in, I think, on 29th of June, Eva Jala and Kefas Katongo. And then a 9th petitioner was found, Kalonde, Moades Kalonde, to raise the same complaint. And from what I understand from insiders, close sources, it is said that the latest complaint was very carefully crafted. It was almost like written by a lawyer. You see, it still doesn't take away the fact that it is still the same matter. If it has been decided for 8 times, and then you still go back to the same body and say, can you rule? You're basically telling the body to say, we are not going to stop coming or knocking on your door unless we get the ruling that we want. And that you see a pattern here between that case and the eligibility case, where you keep going to the same court or to the same body, beating the system until you get the outcome you want. We can't, work like that, because where does that stop? After they have decided, I can go back to the JCC myself and say, there was a case which was decided in 2015 or 2016. I'm not happy. Can you reopen that case? Or even the same case, for example, there has to be finality to these things. There are certain things that may not go our way. I sued Edgar in 2021. Things didn't go my way. I expressed my misgivings about that judgment publicly on Hot FM radio station. In June, the PF at the time even accused me of insulting judges, when all I was doing was to comment on the argument that the judges had made in the judgment. But you respect court decisions, not because they have gone in your favor, but because when you go to court, you have to agree that there are two outcomes. I can win the case or I can lose the case. You can't simply respect these bodies when they rule in your favor. So what we are seeing with the process of the suspending of judges speaks to a revenge that is stemming from the 2016 election petition. As I said, in the absence of the report and based on the information that is in the public domain, that seemed to be the material base, the origin of this matter. Say you ruled in a particular way, and therefore we are unhappy. We're taking you to the justice. You must be removed. If you look at the Constitution, it says you can remove a judge on the basis of gross incompetence and gross misconduct and incompetence, for example. You can't prove incompetence or gross misconduct using one case. You want ideally a pattern of cases, so that there's a pattern here of very, very poor judgment by the same judges. I did call for the removal of those judges myself, using that narrative, using that pattern, because I could draw a case, the Cambodia case, the petition case, and 2 or 3 other cases. You build that. But if you are going to pick one incident consisting of those judges who ruled in a way that you didn't approve and say, I want these people out, it's wrong, because you are creating a very dangerous precedent where the next leader, for example, will come and say, you judges who ruled against this person, you're also being flushed out. It's very important that we stand up and defend the judiciary, because you see, the judicial process that is set in motion by the JCC should result in the strengthening of the judiciary, not its weakening. The manner in which those judges have been removed, have been suspended, for example, as a matter of principle, is something I oppose. I'm not opposed to their suspension if it's done, without any political motive, where vengeance appears with the motivation. And the fact that it was done just before the Edgar Lungu eligibility case started tells you that there could also be a political motive there to make sure that you reduce the numbers of the judges who could hear this matter, because out of those original judges who had the case in 2021, many of them are no longer there. So you have Hilda Chivomba, who has retired. You have the other judge who died, I think, in 2020, somewhere December 2020. I've forgotten his name. Then you have these 3 judges who have been suspended. You have another judge who is not sitting, who was part of that original set of judges who ruled in favor of Edgar. Now, if you are getting even just those 3, for example, you are basically rigging the numbers to make sure that if at all it comes to numerical superiority.
Doc, you've been consistently
appointed by President HH leading the way in terms of getting the numbers done and passing a judgment that will disadvantage one party over the other.
Doc, you've been consistently calling for judicial independence. You've been, bitterly complaining of how the judiciary has been conducting, itself, not only under this administration, but also under the administration of the Patriotic Front. Are you telling us, tonight, Doc, that perhaps maybe we shouldn't be counting on the judiciary to give us the true, case of what we know the judiciary for? We know the judiciary to be a pillar, of our democracy. If there's a last, resort that we need to run to, is the judiciary. But critical people, minds like yourselves, have been critical of the judiciary and some of the decisions that they've been making.
The judiciary exercises its power on our behalf as the public. If you read the Constitution, it's a relationship that is based on a social contract of some kind, to say we are reposing your power we the public are reposing the power in this institution called the judiciary to adjudicate conflict in society. Now, it's an important pillar of a democratic system. If you have pressures like we are having now, there's hate and tension in the country. You have UPND and its supporters, on the one hand, very, very determined that Edgar Lungu and his friend, you should not be allowed to stand. You have Edgar Lungu and his supporters who believe they should be allowed to stand. Those kind of divisions generate a lot of tension in a democracy. It's healthy to have differences. But where those differences are very serious, you go to court in the belief that the court will adjudicate on your dispute in a fair manner that pays attention to the facts of the case as well as the law that is relevant to that specific case. The moment you undermine the credibility of the judiciary, you risk sliding into anarchy, because if people lose the faith in the judiciary, if you take away people's right to resolve their differences in a legal means, you're opening the opportunity for resolving differences in an informal manner, in an illegal way. So you don't want that, because it's in our collective interest that we have a very strong and independent judiciary. But a very strong and independent judiciary doesn't come on its own. It comes from the Constitution. The Constitution is very clear. It actually provides, there's a specific provision in the Constitution that provides for the appointment process to public office to be merit-based. That's a constitutional value principle. The assumption is that the person who is empowered to make those appointments, in our case, the president and the Judicial Service Commission, will exercise that power in a responsible manner by ensuring that the people who end up as judges are men and women who are competent, who are beyond reproach, who are qualified. Now, you have to create a system that would produce those kind of results, and happen on its own. If you look at how we appoint judges in Zambia, it's very secretive. If I asked any judge today to say, how did you end up as judge? They won't be able to explain what is needed. And I think that's a major lesson for me from this experience, as well from the experiences of the past. What is needed is to create a transparent mechanism of appointing judges, so that we don't have this secrecy which is existing now, where judges, where individuals we're just told so and so has been appointed judge. Did they submit a CV to anybody? What was the process? There was no call that there are vacancies, for example, on the judiciary. Anyone can apply if they're qualified. There's no participation in terms of the public to say, okay, there's a Sishuwa has been shortlisted to become a judge. If there's a member of the public who believes that he doesn't possess a judgment to become a very, very fair judge, for example, they should come and testify, not through that parliament route, because we know that parliament is quite often does what the bidding of the ruling party. What you want is to make that process transparent, to create a mechanism where the Judicial Service Commission is not appointed by the president in terms of membership. Because if the Judicial Service Commission, which appoints judges, is itself constituted by the president, it's an indirect way of empowering the president to do the same thing. So what you want to do is to make sure that you create a transparent system of appointing judges, one which involves the Chief Justice. In other societies, the Chief Justice is part of the appointment of judges. In Zambia, it's not. He only gets these judges to work with, for example, and how do you even expect him to have control over the people that he doesn't even know or he doesn't appoint? They're just friends of the executive, for example, friends of those who are in the ruling party. So that's one way we can strengthen our judiciary. The other way, of course, is to deal with the question of how you remove judges. Again, this secrecy we are seeing around the Judicial Competence Commission is not right. These people are exercising power on our behalf, or rather, their authority on our behalf. Why is it wrong for us to know what wrong they have committed in our name? It's important to be transparent about these things. If I've done a wrong thing as a judge, there's nothing wrong with the process allowing the public to know what wrong I've done, and to even hear my defense as well as the case for those who want me out. Everything must be transparent, but we have to create this system. It don't just happen on its own. You can't rely on the individual, on the discretion of the person to think that you appoint men and women who are competent, who are independent, who are impartial. Our successive experience has shown that our presidents end up appointing people who are their allies, who are their friends, even Hichilema, for example. The many judges that he has appointed now, 25 or so of them, we don't know how they were identified, for example. One judge, I know one judge, I can give the example of Greenwell Marumanu. Greenwell Marumanu, if you look at the report of the appointing, the parliamentary committee, which was appointed to scrutinize his appointment, he didn't even meet the qualifications of serving on the High Court. He was less, I think, by a couple of months. But he's a judge now. And the same man, Hichilema, can tell us and say, Lungu had appointed his friends to the judiciary, which is true. Edgar had packed the courts also with his own allies. But the rotten system that Edgar used is the same one that Hichilema is using. You can't improve the independence of the judiciary if you don't change the systems of appointment, the system of that provides for the removal of judges, to make sure that they're truly transparent and involve vetting and public participation.
Well, in case you're just joining us, you're watching This Day with me, Andrew Mons. Our guest tonight is historian Dr. Sishuwa Sishuwa. We take a break. On the back, we continue discussing the eligibility of President Edgar Lungu, but also look at other legal issues happening in our country. Well, thanks so much for still staying with us, Doc. Just before we went on the break, we were looking at, the integrity of the judges that are appointed by our politicians. I would like to take you to the petition that President Edgar Lungu, took both to the JCC and the Constitutional Court. In his application, Mr. Lungu wants certain judges, including the president of the Concourt, Margaret Munalula, to recuse themselves from really presiding over the eligibility and determining whether he was eligible to contest the 2021 elections. I would like to get your thoughts on this decision that the president made to write to the JCC and to the Constitutional Court, over these judges that he feels will rule against him.
Well, I think the first move or action that he took of writing the Judicial Complaints Commission attracted a response from Vincent Malambo saying that he should approach the Constitutional Court, which I think was the correct thing to do. The advice from Malambo was correct. You go to court, you go to the JCC on a matter that involves the misconduct of judges or the incompetence. You demonstrate that. You make your case and say, here is why I believe this judge should be suspended or removed from office. If you read the letter from Edgar Lungu to the Judicial Complaints Commission, it didn't contain any of that. It was misplaced. And I think that Vincent Malambo, the chairperson of the Judicial Complaints Commission, was correct in referring the former president to the Constitutional Court. That matter was decided today. He filed an application, a preliminary issue to asking I think 3 judges to recuse themselves from hearing that eligibility case. Now, if you look at the detail in terms of the application that was made by the former president before the Constitutional Court, the application was very weak. It was based on a weak and speculative argument. You see, the petitioner went to court to say, I want Justice Margaret Munalula, I think Kawimbe and the deputy president of the Constitutional Court, Shilimi, to make sure that they recuse themselves from hearing this matter. There are problems for me with that application. I'll highlight 2 or 3 of them. The first is the timing of it. This case of Edgar Lungu started, I think, in October, if I'm not mistaken, October 2023. If you are going to raise a question of judges recusing themselves from the matter, you should do it at the beginning, because these judges have been there all along. Why are you raising it now? Only days or so after 3 of those constitutional court judges that you appointed yourself have been suspended from office. So from the question of timing, I have problems with that, because it's almost like, one can be forgiven for speculating that. It's like you had a deal with those judges to say, we are going to make sure that I get a favorable ruling because you are there. So when they are suspended, you panic. You go and begin to push for this process in a very hurried manner to say, I want these people to recuse themselves. I don't think that is correct. You see, we should be very careful that in our politics, in our criticism of these individuals, we don't destroy the institution, because these institutions serve all of us, regardless of our political party affiliation. So in my view, the matter should have been raised last year when this matter started, to say, here's the matter, here's my concern about all these judges and why I believe that you should recuse yourself. Unless there's fresh evidence, which has come to your knowledge, for example, to say, oh, I didn't have this information at the beginning, but I now have it. And because of this information, I now doubt the impartiality of the judge. Lungu didn't make that very clear in his application to say this was the case. So the timing makes it very problematic. And then the second problem for me with that application has to do with the reasons advanced. They were speculative. So and so is a relative of each level. You can't leave that the burden of explaining the relationship and how it impacts on you to the person that you are accused. You have to go to court and say, here is the evidence of your relation, stating it very clear and explaining why you believe that would affect the impartiality of the judge that you want to excuse themselves from the case. Again, that was missing. If you look at the other one, Margaret Narula, the criticism was that she had ruled against Edgar, I think, in the 2016 case, and therefore she may have been predisposed to ruling against him even this time. Again, that's very weak, because if you are going to make that argument, then you should also demand that somebody like Martin Musaruke, for example, and anyone who ruled in Edgar's favor in the 2021 case or before should also be asked to excuse themselves, because it means they are biased towards Edgar. From a point of principle and integrity, if you are going to make that claim, you can't simply target Narula and say, I want Narula out of this matter because she ruled against me. You should also extend that to those judges who ruled in your favor. So again, I have problems with that, and because it was in my view based on very questionable timing. It rested on speculative and weak argument, for example, in terms of the evidence adduced. Even Shilimi said, okay, he's a business partner of each. It's true, even the parliamentary committee that was appointed to scrutinize his nomination as a judge of the Constitutional Court made that point and said this person they raised that question of his relationship with the president. Shilimi in his response claimed that he will discharge his duties impartially. It's easier said than done, of course. But if you are going to go to court and ask a judge to recuse themselves, for example, you have to present compelling evidence, especially when you are dealing with the judges, like our own judges on the Constitutional Court, whose judgments leave much to be desired. You want to leave them in a difficult situation where even the public can see, if they say we are not recusing ourselves from this case, that the evidence that demanded that they should step aside was overwhelming and very clear. I didn't get that sense, for example. You can't tease, two of those judges were appointed by President Lungu himself, I think, Kawemba and Munarula. Of course, one of them was appointed the Concourt by Hitchlema, for example. But you can't again say that at the basis that they should be removed, because Edgar Lungu appointed a number of judges. Why are those judges remaining on the bench? Or if you are raising the question of bias on the basis of who appointed these judges. So I think that it was correct in the end that the judges dismissed that matter on the basis of the weak and speculative evidence that was provided. And I think that if you take away, I followed the deliberations in court. If you take away the emotion that they wore when they were, making that decision, when they're reading the decision, if you take away the emotion, they're very emotional, which is very unusual. You see, they shouldn't be emotional if they are standing on a very strong legal footing. It's a question of simply saying, here is the law, here the threshold needed for one to recuse themselves, for example. We don't think you have demonstrated that thing. You don't have to be emotional about it. But if you take away the emotions, the decision that they made today were sound. And I think they were mindful that we're setting a precedent here, because in future, this matter, this case would be used as a basis for asking other judges to recuse themselves. So I think that on the matter of the application for recusal, I agree with the judges' decisions based on the evidence that was provided. I think it was not enough, and I think the decision that they made in relation to that specific application was.
Well, critics of President Hakainde Hichilema, like Makebu Zulu, alleges and accuses President Hakainde Hichilema of having to finger his hands in every cookie jar, making reference to him interfering with the three arms of government. I'd like to get it from your lenses, Dr. Sishuwa Sishuwa. Do you have a sense in which you feel that this administration, President Hakainde Hichilema, interferes with the operations of the other arms of government?
Yes, I have that sense, and I've written about this. This question about whether there's true independence in the operation of the three arms of government. There's none. The one arm of government that has remained powerful over the years, both under Hichilema and his predecessors, is the executive. If you limit our discussion to Hichilema because he's the president now and his decisions have consequences that affect us now, those from the past, we can start them at the reference point in terms of what should not be done. But Hichilema has provided very new examples of how the executive secures itself in various ways. So I call this elsewhere lawfare, where you abuse the law to achieve political ends. In other words, what you are doing is not outside the law, it's within the law, but you are using that power given to you by the Constitution or by law to promote the interest of yourself as an individual, as a political actor, or your political organization, rather than the interest of the republic. The president has power to appoint judges who go and populate, the other arm of government, the judiciary. The assumption is that the person who has been given that authority to appoint judges, for example, will use that authority in the best interest of the country by appointing the right people. Because if we don't have the competent people in these offices, then it undermines the effectiveness and the impartiality and independence of those other two institutions. But what we have seen is that Hichilema has packed these institutions with his supporters. Let's look at the parliament. You have Nelly Muti there as speaker. She has demonstrated consistently over the last 3 years that she appears to see herself as a UPND functionary, there to do the bidding of the ruling party, rather than to serve the interests of that state organ. It's a huge responsibility that requires impartiality, that requires judgment, but you can't blame her because she was put there by Hichilema. What was Hichilema thinking there? He knows that the Constitution allows him to appoint a speaker, working with other parties represented in parliament, and he appointed Nelly Muti, somebody with links to the UPND, to go and preside over another arm of government that should be independent. What kind of leadership are you going to get from Nelly Muti? It's the poverty of leadership that we have seen Nelly Muti exhibit over the last 3 years. You don't build a strong institution that way. You appoint the right people, not cadres, to these key institutions. You go to the judiciary. it's the same thing. This judge that he has put there, he's packing the courts. We don't know why, how these judges are appointed. When he was in opposition, Hichilema was critical of this mechanism of appointing judges, where we don't know how judges end up. And he promised to do better by putting in place a transparent mechanism that would ensure that the men and women who end up in the judiciary are end there on the basis of merit. You know, if you end up as a judge after, say, a competitive process where you are interviewed, where you are scrutinized by many stakeholders, for example, you feel you have earned the right to be there because you have proved yourself through this competitive process. These ones who are ending up there now under HM, like before, they are ending there under the shadow, under the veil of secrets. You can't be condemned if you mistook them for UPND functionaries or allied friends of the president, because you don't know how they ended up there. Again, that's not the right way to build institutions. I expected the HM, for example, to honor his promise, to make sure that before you appoint more judges to the judiciary, for example, you put in place a system that would ensure that we fulfill the constitutional principle that promotes the merit-based appointments to public office. He didn't do that. What does he do? He does the very thing that he condemned when done by Edgar. That kind of conduct demonstrates that whatever HM was saying in opposition was not a matter of principle. He was saying it because it was the right thing to. It was the opportune thing to say it in criticizing Lungu, not because he believed that a matter of conviction. Again, you are undermining that institution that way because you're not strengthening it. The other way, of course, when you talk about the judiciary, is in relation to what the Constitution provides for. It says the judiciary must be adequately funded in terms of his finances. There was a judgment on this matter from the Constitutional Court. I think it was in August or so last year, but it's certain that judgment was issued under Hichilema's leadership. The court made very, very specific directive that the government, Attorney General, the Parliament should do the following, for example, to honor that constitutional provision. Almost over a year later, none of those directives have been honored. So the executive is breaching, is disrespecting court directives. That's not the evidence of somebody who is committed, for example, to ensuring that the separation of powers between the three arms of government, and who is committed to building strong institutions. So in the end, what we see, in my view, is a president who is using the law, empowered by the law to appoint this thing, who is abusing the law, what I call lawfare, to pack critical institutions, the police, the Electoral Commission of Zambia. That's another body I didn't talk about. The Electoral Commission of Zambia. It's a very central body because it manages our elections. Nations can go to war based on how you manage elections. So you want to make sure that men and women who end up in the Electoral Commission are people beyond reproach. Mangala Zarumi's links to UPND are well known. Why do you put a person there if you are really committed to building strong institutions? The critical point to remember is that a democratic government is based on shared principles and values. You've got to identify those individuals, but you also have to create the systems. But dictators don't want strong institutions. A Democrat, if at all was a Democrat, would have long recognized that a strong opposition, for example, is necessary for the functioning of democracy. What are we seeing? The opposition are being stopped in terms of doing their activities by the police, where he has put another, UPND aligned Inspector General of Police. They don't have the freedom to conduct their rallies. You see, what for me is very difficult to understand. That these are the things that Hichilema condemned when he was in opposition. Edgar Lungu and his friends made life very difficult for Hichilema and his friends in the UPND and generally in the opposition. When you have somebody like Hichilema, given his experience, come to power, the expectation from any normal person is that he wants to do the very thing that were done when he was in opposition. What does he do? He does the very thing that he was criticizing Edgar Lungu for, packing critical institutions or capturing critical institutions with by sending his supporters there. Something which is not wrong because the law allows him to appoint these people there, even though the assumption, of course, is that you'll be responsible not to just pack these things with your cadres, but he does the very things. He even undermines the right of the opposition to exist. Again, these are things for me that don't point to a leader who is committed to democracy or to building strong, accountable democratic governance.
Well, as you argue like that, Dr. Sishuwa Sishuwa, there are other reports that seem to suggest that there's been some form of strengthening of Zambia's democracy from the time that Hakainde Hichilema took over as president. Such reports include the VDEM report that does, suggest that actually democracy has grown under the leadership of President Hakainde Hichilema.
I saw the VDEM report and I saw how excited ruling party cadres and leaders were about that report. You see, if I get a report, I should read it and say, here's how you made this conclusion to say things are improving. There must be a standard from where the reference point from where you begin to say, here's where we are starting from. So let's say under Edgar Lungu, for example, opposition parties had been allowed to exercise their right to peaceful assembly. Has that changed over the last 3 years? It hasn't, hardly, okay? So if somebody comes, an outsider comes and says, this has changed and you Zambians must understand that this has changed, you must celebrate, it's very insulting because I don't need to be told by VDEM or whatever mechanism or methodology they use, for example, to make that conclusion, to know that nothing has changed in terms of how opposition parties are treated, to how Edgar Lungu and his friends in PF treated the opposition, including Hichilema and the UPND itself. If you are talking about strengthening democracy in terms of the key institutions, the police, the electoral commission, parliament, public appointments, again, you should show the distinction there to say Edgar Lungu appointed judges using a rotten mechanism. Has that changed? It hasn't. If you are saying Edgar Lungu was arresting opposition leaders and people for all sorts of offenses, has that changed? As I speak to you now, Nakachinda, I don't know if he has been released, was arrested, I think yesterday or the day before. A bondable offense, somebody goes and spends a night in detention. You don't need that. If I have committed an offense, you call me to the police, you read my rights to say, oh, here are your rights, and here's the charge that we are giving to you. Do you admit or not? The police does its job. They complete the process. If you don't agree, the matter goes to court. You are allowed to go home. Why should you punish somebody to go and spend a night in detention just because you want to flex your muscle and show that you are now in charge? So that was happening under Edgar Lungu and his friends, and it's happening under Hichilema. Then somebody comes and tells you to say things have changed. I think that we should do. I think we should have respect for Zambian people. You don't need, as an outsider, you don't need to come and say, you Zambians don't know what you're experiencing. I know better, and therefore here's my report. There's no report, so to speak, because you couldn't read anything to see that are the basis for how they reached those conclusions. Edgar Lungu was punitive. He was showing, he was exercising power in a way that was not proper. Hichilema himself was arrested over what one would regard as a traffic violation and spent 4 months in detention, Mukobeko, over that treason fee. You would think that somebody who went through that experience would never wish, even his worst enemy, if they are really motivated by humanity's moral values, including respect for other human beings, to undergo that kind of experience. What does he do? He sends Mumbipiri to Mongu. She spent a year in detention, and then before she was acquitted, a couple of days before she was acquitted, they entered in knowledge, just like Edgar and his friends did. You can't tell me that shows change. So when we measure change, we must have standards. We must have references points. Say, here's where we are starting. Okay, as VDEM, for example, we are looking at improving democracy in relation to key institutions, the Electoral Commission of Zambia, the police, the courts, for example, parliament. Here's how they operated under Edgar, and here's how they're operating under Hichilema. We should demonstrate those differences. You can't see those differences. But what Hichilema has done is simply to remove what Edgar had done, which is to pack these institutions with PF supporters, and they put UPND supporters this time. That's not the change we voted for. If you are going to say democracy is about respect for human rights, for example, you shouldn't be persuaded to honor your campaign promises. You know what you promised, for example. Hichilema says if you vote for me, this Cyber Security and Cyber Crimes Act that Edgar has passed, my first act in office will be to repeal it. There's evidence online, you can on Twitter account. And what has it done for the last 3 years is to use the same law that he criticized as bad, which was enacted by Edgar and his friends, to deal with his opponent, to arrest his opponent. There must be, that's why I'm saying I think that we should really respect the Zambian people. These people who make this kind of reports and they go and tell the narrative to outside and say Zambia is a thriving democracy. A thriving democracy where the opposition can't meet, they can't even talk. Nakashinda, for example, was making the claim that the state was planning to arrest Edgar. You say that is sedition. You look at Brebna Changala, Edith Nawakwi, Munia Zulu, that woman, the MP, I've forgotten her name. They make political comments. They are arrested for sedition. Sedition is like, it's a new insulting the president law, which the PF and Edgar abused. Now, the new instrument, legal mechanism that HH and his friend, the European, are using to deal with dissent is sedition. Almost everything now that you are going to say is sedition. Probably, if I was in Zambia after this program, I was going to be arrested for sedition, perhaps based on what I've said, for example. Democracy is very noisy. You have to allow people to express themselves. And sometimes ignore. It's not everything that requires attention of the police, for example. Let people debate, let people voice out. You can't have a scenario where people are now quiet, not because they have nothing to say, but because they're afraid that if they are going to speak, they'll be arrested. They'll just wait for the election and vote you out. That's how leaders fail in the end, because apartheid was law. Was it a just law? No, it wasn't. People said, okay, we are going to obey this law, not because we agree with it, but because we fear arrest. That was apartheid. In a democracy like our own, you should not reduce people to that status where they begin to fear even to express themselves. It's wrong. And I hope that the European, particularly Hichilema, you see, sometimes in the still of the night, sit back, go back and see what you promised the people and say, am I honoring the campaign promises I made to the people in terms of strengthening democratic institutions? No one will have to remind each of them he can do that because he made these promises. I read Winter Kavimba the other day saying some of the promises that HH made, he may have been misled into making them. That's very dangerous. But where does that misleading stop? If HH was misled to make those promises, it means he also misled us to vote for him. On that basis, I can call that he should resign because he obtained the power by false pretenses. What is needed is taking responsibility and doing the right thing.
As we conclude very quickly, Doc, what is your expectation, without being contemptuous, over these matters that are in court? Do you foresee the Constitutional Court really diverting away from their earlier position on the case of Edgar Lungu? But also, I've seen a lot of submissions of legal minds stating that if Edgar Lungu was ineligible to contest the 2021 elections, and means that the election of 2021 were a nullity, and we have to start all over again. But what would be the implication, according to your research, Doc, but also what are your expectations in terms of this case that has gone back before the Constitutional Court?
Well, there are two implications that could come. If for example, they said he's not eligible to stand. You see, based on the 2021 judgment that the Constitutional Court made, Edgar Lungu is eligible to stand. And for me, I would not vote for Edgar, but I respect his right to participate in the political affairs of the country based on that. Let people reject it. I don't even think, if you think about it, I don't think that Zambians would vote. If you gave them Hichilema and Edgar as the only candidate in a ballot, they are likely to vote for Hichilema after 10 each because they know that Edgar has been there for a longer time, for example, and they are less likely to be to trust him, given the fact that he had shown very little change, for example. So I don't even understand the basis of the fear that the UPND and Hichilema, the phobia that they are exhibiting towards Edgar, because this is somebody they beat with how many? Over 1 million votes, for example, and the Zambians know Edgar's record. Of course, they are also now knowing Hichilema's record. But if you have an election where you have the two of them competing, I actually think that HH could win. In my view, HH would have done well to leave Edgar on the ballot because there are many people who never voted for Edgar because the memory of what he did is too fresh. So they are likely to vote for him. By removing him from there, actually, HH is opening himself up to a much stronger candidate that Edgar can back, for example, as we saw with the paper in 2015. You can kick out a former president from standing, the way the Supreme Court dribbled the paper banda in 20. But if he supported somebody else, and that person won. It was not necessary, in my view, to take this matter to court in the first place, because when you do so, the implications are twofold. The first is that if you rule that Edgar is not eligible to stand, you are damaging not just the credibility of the court, but of these new judges. Because there used to be 11 judges on that court, okay? 3 have been suspended. Now you have 8 judges. I don't think one of them is sitting. So you have 7 because you need to avoid an even number. You have 7 judges. 4 of those judges were appointed by Hichilema. If those 4 judges, all of them without exception, said Edgar is not eligible, for example, it will be seen like that's exactly why HH appointed them to end up with that court, to make sure that they disqualify HH's main right. The political origins of the case are not lost to many Zambians. The person who started this case, the UPND official activist, and then after it started after Lungu announced his return to politics in October 2023. Then you had the minister Haimbe saying no, that 2021 case was not conclusively decided. Edgar used the arrogance of numbers to get the kind of judgment he wanted. I think we can go very soon. You'll see Zambians going back to court to seek a right judgment. That's what Haimbe told Zambia. Even before that young man went to court to petition to make the case there, Haimbe had told Zambians very transparent about the political nature of the case. How did he know that people would actually wake up and go and petition Edgar? It shows you the connection between that court action and the UPND. So when the judges, the new ones, will go and say Edgar is not eligible, however compelling the argument, you would not be able to dismiss the perception that they were pointed to this court to fulfill the interest of each remuneration to knocking out his main rival. But the court itself will also be, in terms of the remaining credibility that it still has, it will be very difficult to recover from that, because they will be seen the same way those 3 judges are being seen as potentially capable of doing the bidding of Edgar. It means those judges who make that decision in the future, they will end up they're likely to end up before the Judicial Commission. If the leadership changes, the same way they're abusing these institutions, in the same way another leader can abuse the institutions and sort out the judges. That's why you find that in the end, it's always important, even those 3 judges, in my view, those judges should never have ended up on the Constitutional Court bench in the first place. But because of a flawed and rotten system of appointing judges, they are there. And now you have to deal with removing them. But you have not addressed that very system because you have packed your own people there. It's the same way that another leader can come and remove those judges. What does that do? It undermines not just the credibility of those individual judges, even if they may actually be capable, but the credibility of the court itself. Because you can't have a situation where the same court ruled 3 times this man is eligible. Nothing has changed in terms of the law. You only have a new set of judges who come from the leader who has been appointed, who has won the election, and then they come and turn around and say, no, he's actually not eligible. So that's one implication. The second implication is that if they rule that Edgar is not eligible, okay, they have to then go to Article, I think it's Article 1 or of the Constitution, that says any act that violates the Constitution is now and void. Okay? So if they decide that Lungu was not eligible to stand in 2021, it means that entire election of 2021 was illegal and unconstitutional. The entire process that gave birth to it, from nominations, was actually an illegality. Where does that end? It means you have to make a pronouncement about that. You can't just say the Constitution was violated, but it's okay, let's sit back and celebrate because there's nothing we can do. No. If you're making a judgment that says this should never have happened, it means we have to undo everything that transpired from the time that illegality took place. Now, the trouble for the Constitutional Court is to go back to the Constitution and say, we are making this decision based on this particular provision of the Constitution, for example, because if they say we are ordering a fresh election, using what provision of the Constitution? There is no provision that allows them to call for fresh nominations outside what is stated in Article 101, for example. So the Constitutional Court is a creation of the Constitution. They cannot operate outside the Constitution. Whatever they say, whatever judgment they make, they must be able to go back to the law that gives them authority to make that judgment. If they will just say it's not eligible and they sit back without consequences, for example, then you are basically saying it's okay to violate the Constitution because there's nothing that will happen to you. Normally, when the court pronounced themselves that this act was illegal, the normal thing is to restore the status that existed prior to that illegality being committed. That's why I was critical of the Concourt bench, including the suspended judges, when they ruled, for example, in the case of Shimba Kambwili, where Mativini, who was speaker at the time, declared his own seat vacant. He went to court, Kambwili. The court ruled that Mativini's action was unconstitutional, but they stopped short of actually saying you should have, that election that took place in Iran was illegal. They said, oh no, an election has already taken place. If we make a ruling that requires us to go to that pre-violation of the Constitution Act status, it will get a constitutional crisis. Well, it won't. What gets a constitutional crisis is the failure to actually give incentive for politicians and others to respect the Constitution by showing that if you do this and we find that the court that is unconstitutional, we will revert to the status that existed before. Can the Constitutional Court do that? I don't think they will do so. The motivation here is to get Edgar out. For me, I go back to this point that this court, if HH was very committed to building institutions, this court case should have been withdrawn, and most importantly, should never have been started in the first place because it would damage the credibility of the institution. Of course, we have to wait and read the judgment when it is ready and see how they'll persuade us. But because they've accepted the case, they now have to decide. And once they have decided, I hope we can have another conversation to discuss the ruling that they will deliver.
Prominent historian Dr. Sishuwa Sishuwa, thank you so much for creating time to speak to the Zambians this evening.
Thank you so much for having me.
Well, thank you so much for watching. On behalf of the entire production crew, thank you so much. And we'll see you again on Tuesday for another edition of This Day. My name is Andrew Mwansa.